Welcome, everyone. Thank you again for joining us. I am pleased once again to be joined with Professor Stephen D. Schwinn of the University of Illinois Chicago School of Law. Professor Schwinn, thank you again for joining us.
Kathy, it's a real pleasure. Thanks for having me.
So, Professor Schwinn, we are going to chat a little bit today about a case that's getting heard the day after election on November 4th. Fulton versus the city of Philadelphia. This is a pretty high profile case, although not getting quite as much attention as the case being heard the following week challenging the ACA. But could you talk to us a little bit about Fulton versus Philadelphia? What's this case about? How did it get to the court? Why are we talking about it today?
Yeah, you bet. Thanks, Kathy. So Fulton is about well, let's start here. So the city of Philadelphia has a policy where they contract with private organizations, usually nonprofits, to help with their foster care system. These organizations will vet potential foster care families and recommend placement for foster care children in foster care families. One of these organizations is Catholic Social Services, a longtime contractor with the city of Philadelphia in the foster care program, and by all accounts, a really good contractor with the city in this program. Well, the city of Philadelphia more recently adopted a policy that said we can't discriminate by sexual orientation in the foster care program. And they actually put language in their foster care contracts with these social service nonprofits that says they won't discriminate by sexual orientation in the operation of the program. So this standard clause was also in the contract for Catholic Social Services. Well, the city later found out that Catholic Social Services was systematically not placing foster care children or recommending the placement of foster care children in households that had a single head or households that were headed by a gay and lesbian couple. And so the city then contacted Catholic Social Services and said, hey, you know, what's up with this? You can't do this. It violates this term in the contract. And at that point, Catholic Social Services sued and said, well, you can't cut us off from our contract with the city for foster care services because that would violate our free exercise of religion rights. In particular, what Catholic Social Services was saying is, look, we have a religious belief against placing foster care children in households headed by gay and lesbian couples. And so for the city to force us to do that violates our free exercise rights under the First Amendment. The case went on up to the Supreme Court, and there you have it. It's presented at the court.
So, Steve, it's usually when we're dealing with cases dealing with religion, racial discrimination, it's strict scrutiny and it's out. Can you talk to us a little bit about what the strict scrutiny standard is? I know I got tripped up on it all the time in law school. I still do. And why that is or maybe isn't the deciding factor here.
Yeah, you bet. It's a terrific question. And it's important to understand this concept, strict scrutiny, to kind of understand the context of the case and the significance of the case. So ordinarily, under the Free Exercise Clause, if the government targets religion or a religious practice, targets religion for maltreatment, for example, or targets it to discriminate against religion, the government practice is subject to the strict scrutiny standard. Strict scrutiny requires the government to show that what it's doing is narrowly tailored to achieve a compelling government interest. Now, that's all very fancy language for just saying that this is a super high level standard, the highest standard known to constitutional law. And what it almost always means is that a government action will be unconstitutional. So a government action that targets religion will almost always be unconstitutional under that standard. Now, on the other side, we have the standard rational basis review. And so there's a test under a case called Employment Division versus Smith that says the following. If the government has a neutral policy, neutral with regard to religion, but applies broadly across the population, in other words, it doesn't specifically target religion, but it applies to everybody equally. And it nevertheless has what the court calls an incidental effect on religion. Incidental, not meaning unimportant, but rather because it just happens to affect religion. It's not targeting religion, but it has this incidental effect on religion. Laws like that are subject to a standard called rational basis review. under rational basis review, the government action will be upheld if it is rationally related to any conceivable legitimate government end. And again, that's fancy language, but for saying just the opposite of strict scrutiny, this is an extremely low level test. It's the lowest level test known to constitutional law, and it means that almost all government actions are going to be upheld. Now, what this case does is pit those two standards in a way against each other. What Catholic Social Services is saying is, on the one hand, this non-discrimination policy, the way it was enforced by the city, was targeting our religious practice, and therefore it ought to be subject to strict scrutiny and it ought to fail. But then they're saying in the alternative, even if this is only a neutral government policy, neutral with regard to religion, it nevertheless has this incidental effect on our religious beliefs. And it would ordinarily be upheld under rational basis review. But here's the real important part of the case. What Catholic Social Services is saying is that standard, it ought to be overturned. That Smith case that we talked about, the court ought to overturn that case and heighten the level of review for these broadly applicable neutral government laws that have an incidental effect on religion. And Kathy, I think that's the real significance of this case. The way the case is teed up, I think the court is likely to come to that question.
So see, let's say the court takes the bait and goes to Smith, and we get an overturn of Smith. What does that mean? What does the world look like the next day?
Yeah, well, I think that's a really good question. So in some ways, we might expect not huge changes, and let me explain why. After Smith came down, the federal government and states all enacted these religious freedom restoration acts that reset the standard under Smith to strict scrutiny in certain situations where a government action had a substantial effect on a religious practice. Then the government action would be subject to strict scrutiny. And we've been living with, on the federal level, the Religious Freedom Restoration Act and the RLUIPA Act, the act that applies to institutionalized persons at the federal level, and what we call mini RFRAs at the state level. We've been living with these since Smith came down. And so, you know, the world hasn't radically altered under the RFRAs on the one hand. On the other hand, if the court were to reset the constitutional standard under free exercise, it really could allow religions to challenge all different kinds of neutral government actions that have an incidental effect on religion. Let me give you an example. The one that I like to talk about with my students, just to kind of easily get our head around this, is if a local city had a zoning ordinance that said no building in the city can exceed 2 stories in height, right? And maybe they did it for aesthetic reasons. Well, along comes, say, a Christian church that wants to build its church within the city, but erect a steeple that exceeds 2 stories in height. And the city says, well, no, you can't do that. We have this neutral government law. Well, there you have it. Neutral government law, incidental effect on religion, right? How would that come out under a heightened standard under free exercise? Well, what it might mean is that in some cases, religions can get an exemption from neutral government laws that have this kind of effect on them.
Steve, as we're talking through this, I keep going back to Masterpiece Cake, which was decided, 2 years ago, I think? How is this? Just over 2 years. Yeah. How is this different, and why is this not just sort of the issue concluded by Masterpiece Cake?
Yeah, great question, Kathy. So in Masterpiece Cakeshop, remember, the court didn't get to that core issue about whether a neutral government law should be subject to a heightened review or whether it could even stand against a non-discrimination requirement under local law. Instead, what the court said is, in enforcing the non-discrimination law in Masterpiece against Masterpiece Cakeshop, the members of the Colorado Civil Service Commission, they actually made statements that were targeting the religious beliefs of the owner of Masterpiece Cakeshop. And because of that targeting, the court automatically subjected the government action to strict scrutiny and ruled it unconstitutional. Now here, Catholic Social Services claims that officials in the city of Philadelphia similarly targeted them in the way that the officials did in Masterpiece Cakeshop. I got to tell you, looking at the record, I'm not so sure. We don't have nearly the kind of evidence that we did in Masterpiece Cakeshop. And that's part of the reason why I say that this secondary issue, this issue of whether the court ought to overturn the Smith standard, why that's well teed up in this case, because I don't think Catholic Social Services has made a very strong case of religious targeting.
So Steve, we'd be remiss if we didn't chat a little bit about the newest junior Associate Justice of the U.S. Supreme Court, Justice Amy Coney Barrett. And do you, reading the tea leaves, putting your prediction hat on, do you think this is a case where we're going to see Justice Barrett coming out strong during oral argument or during the decision when the opinion's actually put down? And what do we know about what she may or may not think on this sort of issue?
Another great question. We don't have a ton of information about her beliefs on the free exercise clause, but what we can discern is that she's likely to align with the conservatives on this question, and that is in one way or another, striking the non-discrimination provision that the city of Philadelphia applies against Catholic social services. And whether she does that at strict scrutiny or overturns Smith, I think, is the big question. We just don't know, but she's definitely one to keep the eye on. Now, what I tell students and teachers is, we've been on a trend, in some ways kind of a long trend, between the free exercise clause and the establishment clause to really chip away at and really knock down any wall that existed between church and state. And I see this case in that line. And to the extent that Justice Amy Coney Barrett is aligned with the conservatives in knocking down the wall between church and state, I think this is just going to be one more step in that direction. Hey, Kathy, let me ask you a question. So as we're talking about this, it occurs to me that these ideas they're not always the most obvious things that people think about, right? And so how do we present this kind of stuff in a high school civics or government class?
Yeah, I think that's a great question, Steve. I think on its face, this isn't a case that necessarily lends itself as easily as, say, your traditional Fourth Amendment case to a civics and government class. But I think there's some really interesting tensions and some really interesting balancing questions in a case like this, and in some of the other cases we've seen that really sit at the intersection of free exercise and non-discrimination, particularly as it relates to sexual orientation. And I think there's important questions that you can be asking students, and you can be asking students to ask themselves about the role of the court in balancing these, and what are the factors the court should be looking at, and is the court the correct body to be placing a thumb on the scale for one side or the other. I also think there's a really interesting comparison and narrative when you look at these sort of free exercise challenges and these claims of free exercise as they relate all the way back to racial discrimination cases. And Justice Barrett's confirmation hearing, I think, was an interesting way to look at that narrative. She was questioned about Brown versus Board and then Loving, and she agreed with precedent and said that was something she would uphold. And then the next step was Obergefell and Masterpiece Cake. And that was where now Justice Barrett put the brakes on and said, no, these are ongoing questions. But you could see the Democrats on the Judiciary Committee at least drawing that narrative. And I think there's a really compelling timeline of cases to go through with students and look at how the court has dealt with free exercise challenges in these areas, and what factors are they teasing out, and what can that tell us about what's going to go forward. I think it's also a really interesting case to sort of place in some of the other cases we've been seeing. I would look at Bostock from last term, which is the Title VII discrimination case for LGBTQ individuals as it relates to their employment discrimination challenges. This is obviously different than that, but I think it tells a little bit about what the court may or may not do and how they're balancing those rights. That was a Justice Gorsuch opinion that was really focused on the definition of sex, and that this is very different than that. But I think the way the court makes these distinctions and the way it may say Masterpiece Cake was different from here. How does the court make those nuanced decisions? I think it's something that is really interesting to pose to students. So although it's not necessarily, a traditional, here are the different federal government versus state government or the branches of the government, those are all sort of nuanced in here. And there's a couple different ways to untangle those issues for students.
Yeah, I really like the way that you said that, especially the kind of balance between, on the one hand, free exercise, and on the other hand, I think what really amounts to an equal protection principle, right? This non-discrimination. And tying it back, now you raised an important point we don't talk about often these days, but it wasn't really that long ago in our country's history where we heard people making the exact same claim that Catholic Social Services is making against non-discrimination for gays and lesbians, against non-discrimination by race, right? We can easily look to the civil rights era and see that a number of folks claimed that non-discrimination laws, anti-discrimination by race, infringed on their free exercise of religion rights. And making that tie, as you said, between Brown to Loving to Obergefell, and thinking about what does this mean in terms of equal protection, equal rights for same-sex couples, in the historical context of equal protection rights by race, right? I think is a really important way to tie this all together.
Yeah. Well, it'll be interesting to see what happens on the 4th, and whenever we get the decision out on this case. And Steve, I hope we will be able to come back together in this setting and have some further discussion on these issues.
Excellent. Thanks so much, Kathy.
Thanks.